One of the consequences of the attorney-client relationship is that lawyers may be disqualified from representing new clients whose interests are at odds with the interests of their current or former clients. The Second Circuit considered whether an attorney-client relationship formed between a law firm and the policyholders of the mutual insurance company it represented in Murray versus Metropolitan Life Insurance Company. The law firm of Debevoise and Plimpton represented Metropolitan Life Insurance Company, or MetLife, during a months-long demutualization process. During that process, MetLife converted from a mutual company owned by the policyholders to a stock company owned by the stockholders. 11 days later, Darren Murray and the rest of the policyholders filed a class action lawsuit in federal district court, arguing that MetLife, which Debevoise again represented, had violated federal securities laws during the demutualization. 7 years into litigation, MetLife asked for a protective order to block discovery of certain communications between MetLife and Debevoise, relying on the attorney-client privilege. The district court said no, reasoning that the policyholders were Debevoise's clients during the demutualization because they owned the mutual company. 2 years after that, and 5 short weeks before trial, the policyholders moved to disqualify Debevoise. They argued that Debevoise was conflicted out of representing MetLife because it previously represented them during the demutualization. MetLife raised 3 arguments in response. First, the doctrine of laches foreclosed the policyholders from raising the conflict of interest this deep into litigation and just before trial. Second, the policyholders were never even Debevoise's clients to begin with. Third, the policyholders had moved to disqualify Debevoise for purely tactical reasons. The district court granted the policyholders' motion and ordered disqualification, once again reasoning that the policyholders were Debevoise's clients during the demutualization. Immediately after that, the district court passed the order and certified to the Second Circuit the following question for interlocutory appeal: were the policyholders the clients of Debevoise or weren't they?